Good morning. Today is July 10th, 2025. It is approximately 9:30 a.m. This is the matter of an appeal. I do want to clarify this is listed both as Z0099-25, but on the invite it says 0098, but it's the same hearing. It's Z0099-25. This is an appeal by Amber Cohen, and the appellant is the employer KC Marine LLC, I believe, as well. The appellant is present. The owner of the property is not present this morning, although they were advised of the meeting and were invited. My name is Carl Cox. I'm a private attorney appointed by Clackamas County as the land use hearings officer with authority to conduct this hearing and make a determination in this matter. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once filed, this decision may be appealed to the Oregon Land Use Board of Appeals. I have considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. Further, I've not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I will state for the record that I received a link to the download of exhibits that were submitted for this hearing, including things such as the application and the county's initial determination denying the requested replacement dock as specified. And I reviewed the correspondence that was related to that, all indicated as exhibits in the hearing and available to all the parties. This hearing the county is making a record, and at this time, I will ask that the county provide an explanation concerning participation in this hearing via the Zoom platform. Please proceed.
Okay, I think that's my cue. My name's Taylor. I'm a senior planner with Clackamas County. Can everyone hear me okay? All right. I am going to read from a script, might be a little clunky, but here we go. So this public hearing will be conducted virtually using the Zoom platform, obviously. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees that are on a PC or an iPad, you have a raise hand button on the Zoom bar, either top or bottom, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Please be sure to provide your name and mailing address when you begin giving testimony. Once you've provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, and you wish to submit additional written testimony, email written testimony to myself, tcampi@clackamas.us, or you can mail it to the Clackamas County Planning and Zoning Division. And the staff contact email address, my email address, is also available on the webpage where you found the Zoom link for today's hearing. I am pretty sure that going off script here, I'm pretty sure that has been updated from Ben, the original planner of record, from his email address to now my email address. But just in case it's not, I repeat, my email address is tcampi@clackamas.us. And then let's see. Testimony must be received by 4 p.m. on the day that the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by email to the staff contact for the application or by entering it in the Zoom chat function during the hearing. Okay, and that is the end of my spiel.
Thank you. The order of proceedings will be that I will ask the county to begin by presenting the county staff report. That is the matter that's being appealed here is the staff report, and if the county has a presentation to go along with that. I will provide the same opportunity for the appellant to present evidence and testimony and argument concerning why the appeal should be supported and not the original staff decision. Before I close the record, or before I close the hearing in this matter, actually, I will make a statement about keeping the record open and providing that opportunity to all participants. Are there any questions before we begin? Okay, and I do ask that each of you, as you present, as you're called upon and you present your testimony, that you state your name for the record and your position in this matter. Ms. Campy, is that correct?
Yes, that's right. Can't be.
Okay. Do you have a presentation this morning?
I do. I'll go ahead and share my screen. I will be presenting, here we go. I will be presenting the staff report of Ben Blessing, who was the planner that originally processed this application. He's no longer with the county, so I am filling in for him. I'm going to report on the findings that he made, the justification for the denial that he issued, and I'm also going to share some additional findings of my own that came up during my research into this matter.
Okay, and will this be an exhibit submitted at this hearing?
Yes.
All right.
Yep. So any additional the additional information will be provided as an exhibit.
Thank you.
Okay. Get to my controls here. All right. So the file number for this appeal is Z0099-25. The concurrent floodplain development application is under file number Z0098-25. So that is why you might have seen that on other documents related to this application.
Thank you.
The property that we are looking at, whoops. I apologize. This is not the correct aerial imagery. The property that we're looking at, I will go to the next slide and show you, is tax lot number 21E02BA, tax lot 700. The address is 13050 Southwest Fielding Road. It's in the R10 zone. It's approximately 1.4 acres, and it is in the UGB. It's on the Willamette River. I apologize that this aerial imagery is not correct, but I'm going to scoot far ahead so that you can see where we are. There we go. This is what the property looks like. And we'll just go back to where we are in the presentation. Okay, so here's an overview of their proposal and staff's basic findings. The applicant is requesting a Willamette River Greenway permit to replace a previous dock with a new dock totaling 30 feet long and 20 feet wide. These are the dimensions that are noted on page 4 of their submitted application. Those dimensions would total 690 square feet. Also in the submitted application is a page showing the dock dimension plans, and the total length of the dock shown on those plans is 31 feet long and 23 feet wide. So I just wanted to note that the dock may actually be calculated as 713 square feet. And then they're also showing a 300 square foot boat slip, also known as a boat well cutout, which is where the boat would be moored or parked. The subject property does have a previous Willamette River Greenway dock approval from 2006. That's under file number 402-06. I apologize for that typo. That file number permitted a maximum dock size of 400 square feet. We don't have documentation of the as-built dimensions of the dock that was permitted under Z0402-06 because docks don't require building permits, so we don't actually have the as-builts for the previous dock in our permit records, but we do have aerial imagery showing that it was approximately 500, maybe 600 square feet between the years 2011 and 2021. There's also dock research that was done by staff in 2010 to seemingly 2012 that seems to indicate that there was a 500 square foot non-compliant dock at the on this property or in that location, and I will include that research packet in the exhibits. The applicant submitted their calculation of dock dimensions, and their methodology for calculating the dimensions excludes the 300 square foot area of the boat slip. It also excluded a 13 square foot area along the eastern edge, which I'll show in the dock dimension layout in a moment. And so their resulting submitted square footage is 400 square feet. And so staff's findings are that based on the dock area calculation methodology that we have prescribed in the ZDO, the zoning code, that methodology is that the dock is to be, quote, measured as the length times the width of the outer edge of the structure. And so the ZDO doesn't have any provisions that indicate that a boat slip could be subtracted from that calculation. And so staff's findings were that, oh, my text is getting cut off. I apologize about that. The proposed dock did not, the proposed 690 square foot or 713 square foot dock does not comply with that 400 square foot maximum permissible area. So the initial decision was denial. The applicant appealed the decision on June 12th, 2025. This is a site plan showing the subject property, showing the dock at the edge of the subject property. There's the Willamette River. And here is the submitted dock dimensions layout. And so this is where you can see how the applicant is arriving at that 400 square foot calculation. Essentially, their argument is that the dock dimensions should be calculated to account for the total surface area of the dock, the total coverage of the dock, which does indeed appear to be 400 square feet. However, staff's interpretation of the code is that calculating by the outer edges of the structure, length times width, the 300 square foot boat slip area would actually be included in that calculation. This, on the right-hand side, right at the end of the gangway, you can see a 10 foot long by 1 foot wide area of the dock that was not considered in the 690 square foot calculation that I mentioned earlier. And so that's where we're arriving at. The actual calculation, according to the code, would be 25 feet plus 5 feet plus this 1 foot. And so that gives you a 31 foot length times 7 feet plus 12 feet plus 4 feet is 23. So we've got 31 feet times 23 feet, and that gets us to 713 feet of dock area.
And under your calculation, the way you are describing it, it doesn't make any difference then that the 1 foot wide strip above that is empty. It still
Correct.
counts towards the total because it's part of the length and width.
Correct. That's correct.
Okay.
Right.
I just wanted to make sure I had that down. Go ahead.
Yep.
Thank you.
Yep. Alrighty, so now I'm gonna review the findings that Ben made against the approval criteria, which apply to permitting a dock in the R10 zone and in the Willamette River Greenway. First is finding whether the use can be permitted in the underlying zone, which is the R10 zone. Table 315-1 establishes that recreational facilities, which can include private docks, can be permitted on a subject property if it's accessory to a primary permitted use, which in this case is the existing single-family dwelling. So that criteria was met. Section 703 is the section that establishes floodplain management regulations. This dock was separately evaluated, as I mentioned, under land use file number Z0099-25. That application was approved. However, since or if this application is not approved, the dock will ultimately not be authorized. Section 705 of the ZDO establishes the Willamette River Greenway, or WRG, regulations. The first finding here is that Section 705 applies because the property is in the mapped Willamette River Greenway. The second finding is related to the request being consistent with the purposes that are stated in this subsection. This finding is essentially that review, if the proposed development complies with the provisions of Section 705, those provisions implement serve the purposes of the subsection. Ultimately, we found that aside from the dock size, and one other note that I'm going to add here, the criteria appear to be met. So the one issue there is that the dock does not conform to the required size. 705.04B relates to public access. Public access is neither proposed nor required, so this criterion doesn't apply. The next finding is that the request needs to provide the maximum possible landscaped area, etc. This finding is that typical dock construction ensures a maximum possible landscaped area. There's no plan to or permission being issued to deforest that 150-foot area. So this criteria is found to be met. The request needs to result in the preservation of a buffer or filter strip of natural vegetation. It's a very similar finding as the previous one. They're not proposing any deforestation or disturbance of that 150-foot area aside from the affixation of the gangway to the to the shore. And as we see in the following finding, because the proposed dock is a water dependent use, it is a structure that is exempt from the standard 100 to 150-foot setback requirement for structures in the Willamette River Greenway. There's a maximum height requirement for a dwelling or a structure that's accessory to a dwelling. That maximum height requirement is 35 feet. The dock is, of course, not anywhere near 35 feet. It's not a multi-story dock. And on top of that, it's also not considered a structure because it doesn't have walls or a roof. So Ben found that criteria not to apply. Here's where we start getting into specific requirements for private non-commercial docks. So first, private non-commercial docks, boathouses, and pilings need to be dark natural wood colors or painted dark earth tones. The submitted materials did include drawings and materials lists, confirming that earth tones are present. If the dock is indeed approved, a condition of approval, a recommended condition of approval is that they need to show final materials that comply with this requirement. Subsection 705.04 G1 item B. The square footage of docks and boathouses is measured as the length times the width of the outer edge of the structure. This is one of the primary provisions that we're considering today in this appeal. Ben's findings are summarized as the proposed dock is 30 feet by, that's supposed to be, I apologize for these typos, 30 feet long by 23 feet wide, not 32 feet wide, totaling by this, method of calculating square footage, totaling 690 square feet. The applicant's argument is that the boat slip may be subtracted when calculating this dock area. And so as I kind of already mentioned, staff disagrees with this because the above criteria specifies that the measurement is based on the outer edge of the structure. And we don't see any exceptions or footnotes indicating that the boat slip area could be subtracted from that calculation. We do also have some correspondence with DSL confirming that DSL also includes the boat slip area when calculating total dock square footage. That correspondence is included in the exhibits for this appeal. I'm not sure if you can see this on your screen, but DSL correspondence, you can check that out in Exhibit 5, and Exhibit 5A is the DSL dock registration fact sheet, which includes some figure drawings showing how dock area is calculated in different circumstances. That's also described in a little more detail in the staff report. And so ultimately, staff's finding is that even though DSL and the U.S. Army Corps of Engineers, DSL is the Oregon Department of State Lands. Even though both of those agencies have issued permits for the dock, neither of those permits that were submitted by the applicant included evidence that showed how we could apply this subsection of the zoning code in a way that excludes the boat slip. And so therefore, staff's findings adhere to the plain language of this criterion, which would establish the dock area as 690 square feet if we're looking at a 30-foot by 23-foot dock. So that is why this criterion was found not to be met. The next criterion is a length to width ratio maximum. That ratio cannot exceed 3:1. The proposed dock does meet that criteria. And then the following criteria, 705.04 G1 item D, only one dock and boathouse is allowed per riverfront lot of record. The original staff finding is that, and this is true, the proposed dock is the only dock being proposed or permitted on the subject riverfront lot of record. And so Ben found this criterion to be met. I'm gonna provide some additional information below that made it unclear to myself and some other staff as to whether this criterion actually is met. So we'll get to that in a moment. Here is the maximum square footage established in subsection 705.04 G2A. Private non-commercial docks shall not exceed 400 square feet. This is a proposed private non-commercial dock, as calculated according to how we interpret that previous subsection of the code. This proposed dock is 690 or maybe 713 square feet. This exceeds the 400 square foot maximum. Yep. Okay. So this criterion was also found not to be met. I guess I should note out loud, the proposed dock is between Oregon City Falls and the Multnomah County line. So this criterion applies and is not met. I apologize again for this typo up top. The appellant is submitting that both DSL and the U.S. Army Corps of Engineers consider the dock to be 400 square feet. Just to summarize, staff is not finding where those approval actually calculate the dock area as 400 square feet. The submitted U.S. Army Corps of Engineers letter of permission even explicitly identifies the dock as being 30 feet long and 23 feet wide, but there's nothing in there indicating that the boat slip area could be removed from that calculation. And then once again, there's nothing that we can find either in the code or in the submitted materials indicating that we can interpret our code differently on the matter of how to calculate that dock area. So with consideration of what the appellants have submitted and what we have reviewed, we still find that the maximum size criterion is not met. The initial decision, as I said, was denial. The recommendation of staff is still denial. And then, as I mentioned, I just wanted to bring up some concerns that will become relevant only if this decision would be overturned and maybe the dock could be approved and considered to meet the size requirement criteria. There's a concern that, well, there are some questions as to which dock is being replaced, basically. So you can see on the top here, their submitted site plan showing the dock coming out from the subject property. On the bottom of the screen, we have an aerial photo from 2018 showing the subject property. You can see they match, and showing a smaller dock up kind of, way up kind of at the northern edge of the neighboring property to the north, and then showing a very large dock kind of split between the subject property and the neighboring property to the south. So I'm going to zoom in on that just so that it might be easier to see. When I looked back in those dock research records from 2010, 2012, yeah, I'm gonna go to the next page. This northern dock appears to be the dock that was permitted by that previous Willamette River Greenway approval in file number Z0402-06. And this southern dock that is part way on the subject property is filed under the tax lot, the abutting tax lot to the south, which is 21E02BA tax lot 800, whereas the subject property is tax lot 700. And here we can see, once again, this is aerial imagery from January 2025. We see the three pilings in the very top of the photo. I'm going to go back to the previous image. Those pilings are the three pilings. Two of them are connected to this dock. A third one is maybe where the gangway would have been. Those three pilings were related to the dock that was permitted under that previous 2006 approval, which is filed under the subject tax lot, even though it is clearly north of the subject tax lot. And it's possible that our tax lot layer on the map is, a little bit off. I'm not sure. I don't have enough information to confirm that. The middle dock in this image is, like I said, one of two docks on the subject property, or on, I'm sorry, the adjacent tax lot 800. I will include that dock research in the exhibits as well. There are two documented non-conforming docks on that neighboring tax lot. The one of which was documented as being expanded without permits, and one was not. And so then we can also see this southern tax lot. That's the second of the two documented non-conforming docks on this neighboring tax lot 800. Just to make it really clear, this is again from the county dock records related to the subject tax lot 21E02BA, tax lot 700, the subject property. These three pilings are related to the dock permitted for the subject property. You can see next to them to the left, there's a plane parked in this dock. This dock is then shown, here's just more of that. This dock is then shown on the submitted U.S. Army Corps of Engineer permit, with the proposed dock superimposed over the dock that, according to our records, belongs to the neighboring property to the south. So I don't know whether, it's not now clear to me whether they're proposing to replace the dock that once existed connected to these three pilings to the north, or are they proposing to replace the dock that, according to our records, belongs to the neighboring property to the south. This raises questions as to whether more than one dock it relates to the provision limiting the number of docks per lot of record to just one. And I'm just including a little more information showing what we have in the county dock records. This was the dock plan submitted for the previous Willamette River Greenway approval under Z0402-06. This dock shape matches the dock that we see in the aerial imagery for the subject property, right? Matches the dock that's up north of the subject property, but that appears to have been permitted under, filed with the subject property. So all that to say, there are some questions as to what dock is being replaced actually, and whether this application, whether yeah, whether this application actually could even authorize that dock to be replaced because the application was filed under tax lot 700, not tax lot 800. If we were issuing a permit for development on tax lot 800, we would need that property owner's express consent, of course. That concludes my presentation, and I'm not sure if we want to do questions at this time, or I'll leave it to you, Carl, to kind of steer from here.
Yeah, that that is unusual. So the county is looking at it being, so as I understand it, there are two properties that must be to the south of the property that we're discussing. Um, is that correct?
There are two docks on one
On that
property
property that
to the south.
are, while not, they don't meet current regulations, they're predated, so they're non-conforming uses, making them legal, non-conforming uses. But this, it appears to the county staff then that this proposal that we're discussing here um, is in the same location as one of those docks.
Yes. According to the US Army Corps of Engineer permit that was provided to us by the applicant.
And it also appears to the county that those three existing pilings were associated with the actual approved dock, but are not on the subject property
Correct.
or adjacent to it. They're off to the side, but
Correct.
they're in the river,
Right.
so they would be outside of the permit holder's property anyway.
That's correct.
So that's public space. So all they needed was a permit from the Army Corps of Engineers and DSL to put the pilings out there,
Correct.
and then a county permit to attach the dock to the property.
That's correct.
So they could have had a gangplank from the property where it's attached according to a permit from 2006 or whatever, running at an angle off their, instead of perpendicular to their property, out in the river, not perpendicular to their own property. Okay,
Yeah.
that seems legal. But putting the a new dock in, they wouldn't be able to put it where someone else's dock exists, and it's a non-conforming use. That seems to be that's something I would like to discuss with the appellant, actually, and the property owner, because what evidence is the appellant going to have that that they have a right to build a dock where another dock exists and is on someone else's, off someone else's property? That seems pretty questionable. Um, Okay, so I think I've kind of recapped the issues that we need to address here, including, in addition, the original issue, which is whether the boat slip space can be subtracted from the county's calculations, which is, I think, what the appellant came likely prepared to address. Okay, I'd like to provide an opportunity to discuss all these issues with the appellant. Uh, so. Amber Cohen.
Hey,
I'm
thank you all
sorry,
for
but it really appears that this has gotten bigger than you probably came in here prepared to talk about.
all as well. It'll be what it is on that. So my name's Amber Cowan, mailing address 13200 Southeast Hubbard Road, number 10. Would this also be a good time for my coworker Nick here to speak as well and state his?
Yes, of course.
I'm Nick Scanlon. I'm the VP of Sales for KC Marine. I started working with the landowner Barrett Base originally, and so I've been kind of there from stage one, discussing the project and the plans and the goals. Amber's the permit coordinator for KC Marine, so she does the actual filing and things of that nature. My address is 25812 Southwest Canyon Creek, E203 in Wilsonville. Um, and so, yeah, we can provide a bunch of clarity about some of the points just stated regarding placement of dock, which dock is to be removed, permission from adjacent landowners, and all of that stuff. But Amber has a little bit of a presentation to go through first, then maybe we can click back and forth through some slides.
Perfect. Thank you.
Yeah, thank you. Just one moment while I make my screen. So hopefully that is coming through with some level of clarity there. So what we have here is just to start with some clarification on, I guess, the dock we are proposing to remove. We are proposing to remove that large dock shown in our earlier overlay, which was presented as part of Taylor's presentation. Obviously, that property, the dock itself is split partially over two properties due to kind of its age and just being built over those property tax lines. I do believe this is a bit more with Nick's work, but we are in contact with that southern parcel owner as well, who owns kind of the other half of the dock land there for the removal of this.
Yeah, sorry to cut you off, Amber, but yeah, that's correct. The southern landowner, which is Mr. Wiley, I believe tax lot 800 is what Taylor referenced. He is aware of the activity and the proposal, as well as the proposed removal and disposal of this very large dilapidated structure. It is kind of, I don't know how to articulate exactly like the encroachment, but it's anchored with stiff arms rather than pile. And so you'll see, based on the tax map information from CMAP, which is Clackamas County's tax mapping tool, one of the stiff arms clearly comes from Mr. Wiley's property, while the other stiff arm, which serves as the anchoring method for the dock as well, clearly comes from Mr. Base's property. And the gangway landing also appears to be much more so on Mr. Base's property than Mr. Wiley's property.
Okay, and what about the existing, I see that this is a completed dock with this, as you described it, the stiff arms in it, and I saw that it appeared to be split between the two properties, at least the anchors like you're talking about.
Yeah.
Whose dock is this?
Um, so this would be, this is tricky. So there was a previous landowner who lived there by the name of Jamie Green, I believe. And so him and the current southern resident, Mr. Wiley, were friends, and they did seaplanes. And so that both of these docks were used as seaplanes. And so my understanding, just based on the mapping and how the dock is placed and anchored, is that the dock is associated with Mr. Base's residence. But because it is also extended onto Mr. Wiley's residence, that's why we have been in communication with him about the proposed project. Does that answer your question, Carl?
Sort of. So then there's a second dock that was associated with the pilings that are visible in this picture. Where's
Yeah,
that?
that is completely, that's a separate, I don't know those landowners. I don't know anything about that project. I haven't been involved in that. This picture here was actually taken by me just a few months ago, and you can see there's just pile there. I believe it's two pile and then a double stack pile at the end. But there's currently no overwater structure on that northern property. That wasn't removed by me, that wasn't installed by me. And we have no association that I'm aware of with that project, pile or dock.
Okay, so the photo that we saw earlier that showed a dock floating out in the water, what happened to that?
I'm unsure. I don't
Okay,
know.
it's just not
Yeah.
there.
It's not there. Like, from all of my visits to the site.
Okay.
It was not there.
Yeah, not to cut in as well, but the three pile or two and a double you can see here in this image, I believe would have been the pile that dock was connected to in the past. And as you can see, it's not visible, been removed since.
Okay.
Prior
So
imagery.
only those pilings remain.
Yes. Yes. And that is not our proposed activity is the removal of the dock that is currently on the screen, the very large dilapidated dock. That northern dock is not associated with our proposal in any way.
Okay.
Moving forward here, we see again the overlay of what we're proposing against the dock we are intending to remove here, just to kind of anchor us all in where we're looking for the project proposal.
And one more thing I'll butt in here. This is just a superimposed. I'm so sorry, Amber. This is a superimposed aerial, and so Taylor and everybody else, I want to be abundantly clear. I am not proposing placing a longer gangway above and over that dock to a new floating dock. I'm proposing removing that large dilapidated dock. And so basically in this equation, the the existing dock there split between the properties would be removed in full. So this is by no means how it would look in the end. I just want to point that out.
Okay, let's talk just a moment with both of you and the county. As I understand it, what you're saying is that there was a shared dock here that was a non-conforming dock that's been there prior to the regulations on the size of the dock. I saw in correspondence that between Ben Blessing and yourselves that he asked about you submitting an application for verification of a non-conforming use. Now, as I understand what the county's position here is that the southern property owner, Mr. Wiley, has an existing non-conforming use of these two docks that do not meet current standards. Each of them are over 400 square feet. And why didn't you submit an application for a non-conforming use for the property that this thing is on?
Um, I don't know.
Okay,
I didn't know that that was a pathway at the time. I was informed about the Willamette River Greenway permit and the floodplain development permit. I don't
right.
recall now. I'll certainly go through my email threads, but I don't recall a conversation early on with Ben that said, "Hey, Nick, this would be a good permit pathway on the project."
All right.
So I I was unaware.
And I can,
So go,
I,
yes, Ms.
I could
Campy, I'd
spec,
like to hear your opinion.
yeah, I could speculate on that because according to the doc records, which I thought I scanned yesterday, but I'm not finding it in my scans. So I will include that in the exhibits. But according to the doc research records for tax lot 800 to the south, both of those docks are documented in county records as belonging to tax lot 800. And so I don't know if, I mean, it probably occurred to Ben that if the northern non-conforming dock belonged to tax lot 700, the subject tax lot, that would be an easy, obvious pathway to permitting a new, smaller replacement dock that still doesn't comply with the standard 400 square foot maximum. But I believe, if I recall correctly, the the size of the legally non-conforming dock, I think, was around 1,000 square feet. Again, I wish I had the record in front of me. I'm sorry. But I think they probably could get a non-conforming use. It's called a non-conforming use verification and alteration or replacement. It's another type 2 land use application, but it seems like that dock would qualify for that non-conforming use approval, but I do think it would need to be filed under tax lot 800. Or it might need to be filed under tax lot. I'm not sure how you do that when you're yeah, I don't think you could transfer it to a different lot of record.
Well, I think that the argument can be made that it is actually on Mr. uh, Base's property.
Right, yeah, maybe, and maybe,
Barrett, excuse me.
and so it could,
Barrett Base, yeah.
I think they probably could make that argument.
And if they were sharing, if the prior landowner had it and just shared it with this other landowner, who has another dock?
Right.
Yeah, I think it's at least worth considering, Mr. Scanlon and Ms. Cohen, that rather than proceed here, you ask for additional time on this and submit an application for verification of a non-conforming use for a dock that was used by by the property owner here, Mr. Base, his predecessor in interest, at least, on the property, and that what you're actually looking to do is submit an application, as Ms. Campy said, for a verification of that non-conforming use and an alteration of that existing non-conforming use, which would allow the larger dock and as a replacement. Your larger dock than the regulations actually, on their face appear to state. Let's move forward though to Ms. Cohen's argument here about the size of the calculation.
I did want to make one quick additional comment. My apologies.
No.
One of the reasons we did get this far along in the process without putting forth a non-conforming use application is in our correspondence with Mr. Ben Blessing over the last few months. Originally, the issue of the size of our proposed dock replacement was brought up, in his words, as a potential issue or something that may cause some difficulty moving forward. And it was not until directly before issuance of the decision that we were told in certain terms it would not be approved with the current size. And so that was just one of the things that delayed us there on those actions.
Okay. How much, let's see, when did you submit this? June. This is pretty current. Boy.
The original application was submitted on March 10th. And then additional submittal items were received on April 17th, at which point the application was deemed complete.
April 17th.
Mm-hmm. And there's some correspondence between those dates from the incomplete notice was issued on April 4th. And then there's some I think probably the correspondence that Amber is talking about is in Exhibit 4, which is an email thread between the applicant and staff.
It seems a fairly straightforward issue. I don't know what the county staff's timeline is on processing an application for non-conforming use, but you could consider that. Let's talk about your argument about the calculation of the square area.
One. So let me. So what we were running into is that for the most part, we submitted, this is a copy of our letter of permission from Army Corps. Yes. As you can see here, we submitted the figure you've seen a few times here today, the proposed dock design with our calculations. Our calculations are, of course, measuring the individual segments for overwater coverage. This is what we submit to Army Corps, it's what we submit to DSL. These are our standard drawings for our proposed dock systems. And as you can see, we proposed here a total of the 400 square feet, which of course subtracts the boat slip. It doesn't include that in the calculated area. And here we have a section here, this letter of permission permit authorizes your project as depicted on the enclosed drawings. The time limit for completing the work off as LOP ends in 5 years from the date of the letter. So this is our approval from U.S. Army Corps. And if we come down here to, apologies for all scrolling, section 31, new or replacement floats. In this case, our proposed project would be considered a replacement float. The two criteria, you have to meet one of these. The float may not exceed 10 foot in width or 40 foot in length, which we obviously don't meet with our proposed design, or a total of 400 square feet in area. And so here, this reads to us as an approval from Army Corps stating that our proposed float system, the dock, does not violate their criteria of being above 400 square feet.
Yeah.
Let me pull up my speaking notes here. I'd also pull up now our approval from DSL, which if we come here to the approval from DSL, the same image has been submitted, dock dimensions listed as 400 square feet. Here we have projects submitted to DSL have to enter a period of public comment in which agencies check it over. And so this was viewed during public comment by the DSL proprietary, Oregon State Marine Board, and the Oregon Department of Fish and Wildlife. And the issue that was raised by them in this public comment was the nature of these comments. Permittee will need to show that they have proof to demolish existing dock and obtain DSL waterway structure registration. ODFW and Oregon State Marine Board will not have any issue as long as the dock does not extend further. So none of these agencies brought up that proposed size as a potential issue. None of them commented upon it. Importantly, Department of State Land proprietary are one of the two parts of Department of State Lands which cares about the size of docks going in, and they have not taken that registration that we put forward, or they have not taken our proposed dock size as over what they would assume as stable limits. So they had no issue raised, at least, with our proposed size.
And real quick, Amber, just so I'm following here, what you're saying is, even though it doesn't say in the permission, in the permit, you have permission for a 400 square foot dock. It essentially says based on the figures provided, and they attached the figures we provided in this approval that stated it as 400 square feet.
Yes.
So, yeah.
And then I come down. Apologies. Just some more notations here from DSL's approval. The proposed project conforms to sound policies of conservation because adverse effects to the aquatic resources have been reduced to the extent practicable, and the proposed permit contains operating conditions for the best management practices to further minimize adverse effects. No interference with public health, safety was identified in the application, evaluation, and public review process. Interference will only be an issue if the overwater structure extends further out into the waterway than is proposed. There is no conflict with existing public uses of the affected waters in adjacent land use identified in the application evaluation and the public review process. A conflict will only be issue if the overwater structure extends further into the waterway than proposed. And the last thing I have here is I made mention of the DSL proprietary, which, if my understanding is correct, is the part of DSL which primarily concerns itself with the registration of structures and waterways. I reached out to our common point of contact, Michael DeBlasi with Department of State Lands, regarding the volumetric calculations. Wrong image, my apologies. And I received this response, which is, this is the answer only in regards to the removal fill program, the proprietary program, which signed off on the permit when it was sent to public comment, did approve. But for overwater structures, we look at the material that is considered fill below the ordinary high water mark. While a structure will float on and above ordinary high water at certain times of year, it will lower to below ordinary high water elevation as the river level falls. A boat slip is an empty space within the structure's footprint, and thus no material that can be considered fill. However, if the slip has a cover or some sort of other structure over it, that could potentially be considered fill. We do not count gangway in total volume/area. So I was then later provided with contact information for someone with DSL proprietary. I was unable to eventually reach them via phone, so I was not able to get any further clarification on the proprietary. But that is kind of the thrust of our argument here.
Okay. And will you submit all of the items that you just showed in your presentation as exhibits?
Yes.
Okay, perfect. Thank you. Go ahead.
I was gonna stop sharing the screen. I just wanted to check with Nick to see if he had anything to add.
No, I think that pretty well covers it. Did you have the figure? I don't have it. Did you have the figure that just kind of shows boat slip or boat in boat slip versus boat slip along or boat
Yeah,
along
yeah, I can
dock?
pull that up. Apologies.
Yeah.
We moved a little past the initial argument there. Let me pull that figure up for you.
Okay, thank you.
Apologies, I'm not very good with Zoom. It takes me a moment here to share my screen.
No, it's all good. Yeah, could you go back one slide, Amber? I'm going to comment on something. Is that okay if I talk for a second here, Carl
Of
and
course.
everybody? Okay.
I don't find it's a small group. It's not
Okay.
confusing to me at all.
Okay. So this is kind of our project purpose, right? You can see this is a really big, really cruddy old dock. We have permission from Mr. Wiley, the landowner, to remove and dispose of the structure as part of our activity. You can see it's got the old tire bumpers on the side there, and due to the age of the dock is now the flotation and logs are saturated and sagging into the water. So those tires are contacting our beautiful river. It also has exposed foam flotation. That was the construction method used in these times. And that's kind of a known contaminant and not a material that we work with anymore because it's not good for the water. And so that's kind of a big part of our project purpose, right? Is to get this large, dilapidated structure out of the water, replace it with something smaller and with compliant materials, things that allow sunlight to pass through, fully encapsulated float tubs, so there's no contamination into the river. And so we really have a lot of environmental considerations with the project as well. Materials used, square footage represented, as well as just sheer volume. This is a very large existing structure. Can we go to the next one there, Amber? I should have done this myself. Yeah, here's kind of just an illustration. And I don't mean this disrespectful in any way, shape, or form, but you can walk along. The figure on the right is our proposed design. Anywhere where you see that grid pattern is the dock, is the actual overwater structure. The white or the blank space would be the river in this case. And so
Mhm.
you can walk on the dock on those gridded portions there, but you cannot walk in the boat slip. The boat slip is the river. The boat slip is the water. Um, and so we just drew this up just to kind of articulate. The figure on the right shows the boat pulled into the slip. The figure on the left shows a design that would um, conform based on the standards Taylor shared with the measurements. And you see the boat in this case is just parked kind of on the inside of the dock. And so essentially the point here is it's kind of like the same general area that's used, regardless of if the boat is in the slip or alongside of the dock. And then could you go to the next one here, Amber?
I believe the next slide is just blank.
Do we have that volumetric calculation, that stamped one?
Yes, I can pull
Okay.
up,
Yeah. Oh, perfect. Thank you. Yeah.
zoom in a little bit here just because it's a large page, but
Yeah. And so, yep, this is just from an engineer basically stating the significant difference in volume from the structure we're proposing to remove versus the structure we're replacing it with. And so there's just some information there regarding the volume as well as the area. So um, yeah, that's what I got.
I I think you were both very effective in communicating your argument here, and I'll want to go over these exhibits and really consider this. Um, about the are you is there any intention by the property owner to submit an application for non-conforming use here and after our discussion?
That's something I'll need to talk with Barrett about
Right.
further. I was hopeful he would join today, but I can certainly discuss this with him as soon as today.
Okay.
I need to actually I would need to speak with Taylor. Maybe Taylor, Amber, and I can schedule a phone call because I need to learn more about that process.
All right. The reason I'm asking, and I have a question of either Ms. Campy or Ms. Nesbitt. If this is denied, does that, is there a period of time before they can reapply?
Yes, if it's denied, there's a 2-year time limit before they could reapply.
If this decision here is denied?
Correct, unless they
Right.
have a substantially different application. So so if it's denied because you agree with how staff and DSL interpret dock measuring, and then they resubmitted an application that we could approve, we would consider that one to be substantially different because it is approvable.
Mhm. Now, I wish that the property owner was here to make a decision about this,
Yeah,
because I'm not the initial decision maker on whether could be a non-conforming use, or that whether that would be appropriate.
yeah,
It has to go directly through county staff.
correct. And then just
And
just to reiterate, sorry, I cut you off.
no, I appreciate it.
Okay, I was gonna say, just to reiterate, on the non-conforming use side of it, as Ms. Campy said, you can't transfer a non-conforming use from one lot to another. I know,
Right.
Mr. Cox, you brought up it's apparent that it's on both, but the original approval was, I believe, Taylor, correct me if I'm wrong, the original approval was for the adjacent lot. And it just appears that it was built on both, so that would be something that would need to be looked at. Was it really intended for both of the lots? We would need evidence for that. And then, and potentially the other issue with that is, I believe that the lot we're talking about today did have a dock. It was a non-conforming dock, and that's what those 3 pillars were used for. So was it really intended to have a shared dock and their own dock? And then,
I
of
think
course,
that's perfectly valid,
yeah,
particularly as the application that was submitted for the dock with the pilings would have indicated that, there wasn't a dock, and that there would only be one dock on this property. So it
yeah,
seems to conflict. So I
yeah,
agree.
yeah. So
That's
those are
why
just
this isn't
challenges,
the right forum to actually make a decision on any
right?
of this.
Right.
I'm
So I was just
flagging
saying,
that if you want to try, you have to go
yep,
through the appropriate
right.
procedure and submit evidence, and make your case that this is actually, a valid or verified non-conforming use or you'd have to verify that it's a non-conforming use on this property.
Yeah.
So anyway,
Yes, I just wanted to highlight those challenges.
yeah, I
And I
agree.
realized, yeah, it's a totally separate process. But of course, the applicant has the option of, do you want to move forward with this one? And as Mr. Cox was highlighting, a denial is there's a 2-year time limit unless it's substantially different. Or do you want to toll the clock and,
Try
um,
it.
go, look into the option of applying for a non-conforming use and then withdrawing this application? Sorry. It's a
So
lot.
let me make a statement for the record here. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? What this means is that I would typically, uh, if there's a request to keep that record open, to do this, keep it open for a minimum of 7 days for any party to submit new evidence, a period of 7 days for rebuttal evidence, and then a final 7-day period for just the applicant or appellant in this matter to submit a written final word, a last statement about why their position is correct. That does not include new evidence, but just is an argument based on what's already submitted. Now, if any of the parties wish to make that request that the record stay open, I would certainly agree to that. And then that would provide in addition, time for the appellant and KC Marine LLC staff to discuss with the property owner if they would like to try to move forward with an application for verification of a non-conforming use and alteration of that use. If, as Ms. Nesbitt referenced, if additional time is needed, beyond what I'm talking about here, you would need to discuss with the property owner tolling the clock on this application to make room for processing of an application like that. Did I fairly state that and cover that? Okay. I just wanted to flag the concern that if ultimately after I review all of this evidence, the exhibits, the arguments that were made here, that that if I were to decide that the staff decision is correct, it would be another 2 years before an application that was substantially the same as this one could be submitted. And I don't want that to be a surprise to anyone. Okay. All right, so you have some things to think about. Is there a request to keep the record open? And
Yeah, Carl, if I could just comment on a couple things, and Lindsay as well, just to clarify. Obviously, I need to have a discussion with Barrett and see steps moving forward that work best for him and his family. But Lindsay, is what you were saying is that not that we could not reapply for 2 years based on the current design, but if there was a substantial change to the design, it could be submitted as a new application. Am I understanding that correctly?
Yes, so if you chose to move forward with this one and if you chose to move forward with this one and Mr. Cox denied it, you can resubmit a different application before 2 years with a different design.
Okay.
Because it would have to be a substantially different it'd have to be a substantially different application, and that's defined in our code. But typically, if you submit something that we could approve, it would be substantially different because well, because it could be approved. It's,
Okay,
so.
sure. I just wanted to make sure I understood that fully.
Yep.
Not that there could be no application again for 2 years. There just couldn't be the same application for 2 years.
Correct. Yeah.
Okay, thank you. Thank you for clarifying.
Yeah, it's just a way to keep people from reapplying for the same thing
Sure.
over and over again. Yeah. So
Sure.
right. And to clarify, what I understand is the situation and why I flagged it is, yes, you could apply a substantially different application. Let's say, I'm not saying that I've made a decision here, but if I were to deny it, saying that it did not meet the standard of 400 square feet, and you submitted a new application with a new design showing a box that was 400 square feet on, then the county would process that as different and likely approve it, and that would be the end of it. But you couldn't then go and say, I want my same application because this is, a non-conforming use or something. I don't know. You might be able to get it as an alteration of a non-conforming use rather than a new application. So yeah, you could probably still do that as well. Okay.
Thank you for clarifying, Carl and Lindsay.
I think I fairly stated that, talking it out loud. All right. So is there a request to keep the record open? Or do we want me to make a decision based on the record that's submitted and the exhibits that I'll have a chance to review that need to be submitted by 4 p.m. today, actually? Any requests for a record to stay open? No? Okay, then all of the exhibits that the parties want me to consider need to be submitted to Ms. Campy by 4 p.m. today. I strongly advise that you do it before that. I have run into an issue where, oh, it got stuck in email and didn't get there till 4:15 or whatever. Let's see if we can avoid those type of strange technology occurrences. I will review the information as it's following this hearing, all of the exhibits that are submitted by 4 o'clock today, the testimony that was provided, and I will issue a written decision. Thank you all. It was nice to participate in this hearing with each of you.
Yeah, thank you very much, everybody.
With that, we'll close the hearing.
Thank you all for your time.
Yeah, and I'll close the record after 4 o'clock today. Thank you.
You.
Thank you all.